Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Welcome to Synergy's Third Thursday webinar. My name is Jason Lazarus, Chief Executive Officer and founder of Synergy Settlement Services. Today I'm going to talk to you about closing cases compliantly in 2021 and beyond. We have quite a few complicated topics on tap for today, so the agenda is to cover all of these topics to give you an overview and hopefully a better understanding of the issues that you face at settlement. To start with, I'll address the failure to advise and the ethical issues and malpractice concerns that arise at settlement. When you boil it all down, there's really two questions to be concerned with at settlement. What is your obligation to advise the client regarding public assistance preservation techniques? And what are your obligations to advise that client regarding financial options at settlement? So there's several different laws that are at front and center when you're trying to answer these questions. That's 42 U.S.C. 1396 PD4, which is the section of the code that authorizes trusts that preserve needs-based government benefits like Medicaid and SSI. Section 104A2 of the Internal Revenue Code, which gives injury victims two different options when settling their case, whether to receive the money in a lump sum or future tax-free payments via structured settlement. Constructive receipt, which is a tax doctrine, which if you trigger that can cause problems for government assistance programs as well as for options in terms of the financial side of things when you trigger it. And then the Medicare Secondary Payer Act, which we're going to get into in a lot of detail. But when you look at the ABA Model Rules of Professional Conduct, informed consent and consultation, these two provisions, if you read them together, you've got an obligation to explain issues so that a layperson knows what their alternatives are and can decide based on informed consent what to do. And where there are issues that require consultation from those who are not lawyers or other experts, those types of consultations should take place. And if you look at the last two quotes, these two are both, I think, really succinct ways to think about this. You've got to make sure that your client is informed about the options of structured settlements, trusts, and the effect of a settlement on the client's government benefits, and make sure that the client's interests are best served by considering the tax implications of the settlement. The Grillo case is a cautionary tale when you fail to address these issues. So this was a case that emanated out of Texas, was a medical malpractice claim for a birth injury that turned into a legal malpractice claim because the issues about structured settlements were not explained to the client, nor was a special needs trust set up. So the client lost not only their government benefits, but the tax break for a structured settlement. And then ultimately the case was settled against not only the attorneys that handled the case, but also the attorney that acted as a guardian ad litem. And those are some pretty big numbers that you see there for a legal malpractice case. So you don't want to wind up in a scenario like this. So the best way to avoid an outcome like Grillo is to understand what the duties are. And these are my opinions about the duties, but I think they're consistent with what I've explained to this point. So the laws that impact settlement have to be explained because you as their lawyer are the only ones that can explain it to them, or you have experts that you hire that do it. If you fail to, there's no way the client can make an informed decision and loses the opportunity to exercise options that are available to them under the law, which can have damages that flow from it. And I think Grillo's message in all of this that I've spoken to you already is to make sure you employ or consult competent experts in taxation, trust, and financial advisors and structured settlements prior to settlement. And if you don't address these issues, who will, since they are legal issues? And oftentimes I'm asked about a threshold. Well, what triggers these duties? Well, if it's someone on government benefits, it could be as little as $2,000. If you give that to the client, they could lose their government benefit eligibility. So it's quite a low threshold. The easiest way really to remember all these duties is this acronym CAD. You want to make sure you're consulting with your client and with competent experts to make sure that they get the advice they need, and then document your file what was done so that you can show if there are malpractice claims alleged against you in the future that you did everything possible to educate the client on their options, and the client decided to do what they did after being educated about what these issues are all about. So let's now transition to an overview of government benefits, since this is an area that there's frequently confusion and there is a lot of malpractice issues that can arise without proper education. So this chart shows you the two primary different groups of benefits, those that are needs-based, income and asset sensitive, which are the SSI, Supplemental Security Income Program, and Medicaid programs. And then the entitlements, which are not income or asset sensitive, SSDI and Medicare. Frequently, clients confuse all of these different benefits because they say they're getting disability, but that could be SSI or it could be SSDI, depending on whether they've worked enough quarters and what their financial situation is. And what you'll see on the far right-hand side is some information about liens. Next column tells you the different planning solutions to keep those benefits intact, and then the asset and income sensitive column telling you whether it is or it isn't. If you'd like a copy of the presentation, we'll send it to you, and it'd probably be a good idea to print this out and have this somewhere that you can refer to it, because it's a pretty handy guide for seeing the differences and understanding them in a succinct manner. So why do people who are disabled need planning? Well, the primary purpose is making sure that their government benefits are preserved, because that can provide financial support and medical care. Also, having a disability planning technique implemented will provide supplemental lifetime financial support for the client from the recovery that you've gotten them. And most importantly, creates a system of advocacy to preserve the rights of the injured party when they've got a disability planning trust in place. That gives them a team of knowledgeable experts who can manage their affairs for them for the long term. And that's important for people with catastrophic and disabling injuries. But not every client will need that type of disability planning. It's only for those clients who are so severely disabled that they meet the definition of disability for government benefit programs. And on top of that, they need to be receiving government benefits that are potentially jeopardized by the settlement, which are SSI and Medicaid recipients, Medicare beneficiaries, that's the Medicare Setasides issue, which we'll talk about later on in the presentation, and those that are dual eligible, so those that get both Medicaid and Medicare benefits. Now we'll turn to a discussion about the needs-based government benefits, which are Medicaid and SSI. Supplemental Security Income, or SSI, is a cash assistance program for those 65 or older, blind or disabled. Current maximum payments are $794 per month if single, $1,191 per month if married. If the client's receiving Social Security payments in excess of those, then their likely eligible for SSDI, and that's kind of a shorthand way to know if they are getting SSI versus SSDI, but you do want to confirm that by getting a statement from Social Security. For SSI, there is no requirement of having working quarters, unlike SSDI, which you do have to have working quarters to qualify. SSI has an asset cap. It's $2,000 if you're single, $3,000 if you're married, and it also has an income cap. The asset cap is something that you have to be keenly aware of, because if you give a client a $5,000 net settlement and they're on SSI, you've just rendered them ineligible until they spend down below that asset cap. And then Medicaid is the basic healthcare coverage for the indigent. In most states, $1 of SSI automatically gets the person Medicaid coverage. So you want to make sure that that SSI benefit is preserved in most instances so that they can continue to get their Medicaid coverage. When you represent a client who's on Medicaid and SSI and they're disabled, that's when you want to consider whether a special needs trust should be established. If assets are in the name of a person with a disability, then that would eliminate eligibility for SSI and Medicaid. So in the context of a settlement, when you give it to the client, in the month of receipt, it's income. The very next month, it's an available resource if it exceeds the cap of that program. So it's really important not to give a client too much in assets, because that will cause them to become ineligible, which means they will lose their SSI and then accordingly lose their Medicaid if that's their only health care coverage. That can be devastating. In personal injury settlements, there are three types of special needs trusts that are routinely used. The first is a standalone special needs trust, which can be established for anyone disabled and under the age of 65. Next is a D4C pool trust, which can be established for someone that's disabled of any age. And then a third-party special needs trust, which is established with not the injury victim's own money, but either a fundraiser or a parent looking to set up a trust for a disabled minor beneficiary. That's where it can typically arise. So just remember, third-party trusts are only for instances where there are additional monies that are not the injury victims. So the advantages of establishing a special needs trust for an injury victim is that they first and foremost keep their SSI and Medicaid intact. They get a professional trustee that can help manage the recovery and keep them eligible for their government benefits. In most instances, if someone is incapacitated or a minor, it'll avoid a guardianship and the annual reporting requirements. And then a special needs trust can really pay for anything that improves quality of life. The only exception is it can't pay for food or shelter if they receive SSI, because that would basically reduce the SSI benefit. The disadvantages to establishing a special needs trust is that the client does not have unrestricted use of the money. There is a sole benefit rule, which means the trust monies can only be used for the trust beneficiary themselves. So you can't use it for other family members or for children. At death, Medicaid must be paid back out of what is left over in the special needs trust. If there's nothing, Medicaid gets nothing, but if there are dollars left, there is a requirement under federal law that Medicaid be paid back. The only exception to that are third-party trusts. Those do not have to have a payback requirement. It's not the injury victim's own money in that situation. These trusts do add an extra layer of complexity, and the trust is irrevocable, so it can't be undone. One thing to be extra cautious of when settling cases are deeming of assets, because when you settle a case, say you're settling a case for a minor who's got a birth injury, mom and dad have a consortium claim, the minor's settlement is put into a special needs trust, but mom and dad are given $100,000 for their consortium claim. You have just disqualified that minor child because mom and dad's settlement of $100,000 is deemed to the minor child, meaning it's like that minor child got the $100,000. So you got to be really careful about that. But also you want to remember there are things that are exempt assets. So house and a car are two primary exempt assets. So oftentimes settlement monies can be used to purchase those exempt assets if there's a desire to just simply spend all of the money on assets instead of setting up a special needs trust. So there are are a lot of options. You just have to consult with experts and determine what is best for the client. Pooled special needs trusts, which I mentioned on the previous slide, are a really great solution for many personal injury settlements because they're managed by a not-for-profit, so there's no minimum deposit for the trust, unlike standalone trusts where trustees typically want $1 million or more to manage a special needs trust. There's also no age restriction, so those over 65 can establish it. The beneficiary joins an already established master trust, so you don't have to draft an individually tailored trust document. Its person joins the pool trust by completing a joinder, so it's quick and easy. Typically the fees are lower, and the small trusts are readily accepted by not-for-profit trustees. You want to be careful when you're evaluating pool trusts though, because many of them are established for the elderly qualifying for nursing home care, whereas there are some trusts that specialize in personal injury settlements. So you want to look for a not-for-profit that understands personal injury settlements and the issues that go along with that. You want to make sure that the services available to the beneficiaries are robust. For example, TrueLink is a financial services group that many trusts partner with, where the injury victim has a financial advisor that's managing all of their assets that are in the trust, and also get a credit card that's a smart credit card that allows easy spending of the monies that are in the trust, or easier spending. Or say the trust is employing a family member as a caregiver, there's a service through Teams that allows that person to be paid as a wage earner, get workers' comp coverage, have taxes withheld. You want to also evaluate the fee structures, and lastly, most importantly, a retained funds policy. So remember on the last slide I spoke about payback requirements. So with a pool trust, those payback requirements are waived in certain circumstances, and the trust can retain assets. At death, many pool trusts will retain 100%, but there are many that have very low or very reasonable amounts that are retained at death, so you have to evaluate that. One last option to talk about when talking about preservation of government assistance are ABLE accounts. These don't get used all that frequently because the client would have to have been disabled prior to age 26. There are maximums that you can contribute, and it typically is used in conjunction with something like a pooled trust or another vehicle like a structured settlement funding the ABLE account. So it's not used all that frequently, but it's good to understand that there are a lot of options, and this is where having an expert who can advise about these different solutions is imperative if you represent someone that receives government benefits that are needs-based. So while we're on the topic of Medicaid, let's talk a little bit about reducing Medicaid liens pursuant to Allborn. The Allborn case from the United States Supreme Court set the precedent that Medicaid can only recover from a personal injury settlement that the portion that represents past medical expenses. And that's been affirmed by most recently the Was case in 2013, where the U.S. Supreme Court was asked really to overturn Allborn and was looking at North Carolina's third-party liability recovery statute, which had a very dogmatic formula for recovering from an injury victim's settlement, and it allowed for recovery beyond the portion that represented past medical expenses. And what the U.S. Supreme Court found, that the statute was not compatible with the federal anti-lien provisions and violated the holding of Allborn, which precludes encumbrance of any portion of a settlement not designated as payments for medical care. So using Allborn and Was, every state should comply with the dictates of these holdings and reduce their lien in a ratio in proportion to the total value of damages and the actual recovery, which creates that ratio which most attorneys are familiar with in reducing liens. And you want to make sure that you're using that aggressively with Medicaid programs to reduce a Medicaid lien. So now we'll turn our attention to the entitlements, Medicare, and SSDI. SSDI, unlike SSI, is not income or asset sensitive. It's an entitlement. It's funded by the taxes we all pay on our wages. If somebody has enough quarters and a qualifying disability, then they get SSDI benefits. If you receive SSDI benefits, then you get Medicare entitlement within 30 months of disability. That 30-month is calculated by a 6-month elimination period before you get your first SSDI check, and then 24 months thereafter you get Medicare coverage early if you become disabled prior to retirement age. So traditional Medicare coverage is Part A and Part B. Part C are Medicare Advantage plans run by private insurers that are funded by the Medicare Trust Fund. Those are called MAOs. Part C plans. Those can be elected into if somebody's on traditional Part A and Part B and decides to go into a Part C plan. And then Part D is prescription drug coverage. So now that we've talked about SSDI and Medicare, next we need to address the Medicare Secondary Payer Act and its obligations. The Medicare Secondary Payer Act is a pretty complex piece of legislation, but at its heart, it basically says that Medicare is supposed to be secondary to all forms of insurance, but Medicare can conditionally make payments when a primary payer does not, such as a workers' compensation program, a liability insurer, or no-fault insurance. So according to CMS and Medicare, there are two obligations that are created under their interpretation of the Medicare Secondary Payer Act. Those are from the date of settlement backwards, which are conditional payments that I referenced, and then from the date of settlement forward are Medicare Setasides and futures. These issues have become much more at the forefront these days because of Section 111 reporting. Section 111 reporting requires defendants and insurers to report settlements with Medicare beneficiaries of $750 or greater in gross settlement proceeds. So nearly every settlement with a Medicare beneficiary is going to get reported to Medicare. That reporting includes date of loss, ICD codes, lots of identifying information. It gives Medicare a tremendous amount of data to analyze whether conditional payments have been satisfied, but also potentially cut off future eligibility for injury-related care for a Medicare beneficiary. So first, let's turn our attention to Medicare conditional payments. Really, the key issue here is that if you represent Medicare beneficiaries, you have to have an MSP compliance program within your law firm to make sure that mistakes are not made. And why you need that will become abundantly clear when I talk about some of the most recent actions by the Department of Justice against law firms. In 2018, the Department of Justice got very aggressive about going after law firms, and this particular instance was a very small amount of money, relatively speaking, $28,000. But what's important about this are the statements that were made in the press release, which that the settlement between the plaintiff personal injury firm and the Department of Justice should remind personal injury lawyers of their obligation to reimburse Medicare for conditional payments after receiving a settlement for their clients. And when an attorney fails to reimburse Medicare, the United States can recover from the attorney, even if the attorney has already paid the proceeds to the client. That's Medicare and the DOJ's position when going after law firms. So understanding this potential for Medicare to come after your law firm is important in understanding the risks associated with all the things that go along with Medicare conditional payment resolution. This next action against a law firm by the DOJ occurred in 2019. Obviously, this is a much larger amount of money involved, where a law firm agreed to pay the Department of Justice and Medicare $250,000 to resolve an outstanding debt related to their clients. And this one is actually really important because it raises an issue that frequently is misunderstood. And I want to talk about that and explain to you what occurred in this case so you have a better understanding of how to avoid it. So in this case, the law firm did everything right from the outset. They gave notice to Medicare that there was a medical malpractice action going on. Medicare issued a conditional payment letter indicating that the amount that had been paid by Medicare was $14,990. Where things went awry is that the law firm relied upon that figure to settle the case. The case settles, Medicare is notified of the settlement, and there's a settlement detail document that is sent to Medicare. And then 60 days thereafter, which is normal timing, a final demand was issued for $330,000. The law firm did an administrative appeal to dispute that $330,000 amount. The U.S. Attorney Office sent a letter demanding payment. The law firm ultimately turned it over to their E&O carrier, who paid that $250,000 settlement. So why is this important? Well, you cannot rely upon a conditional payment letter. The only thing that binds Medicare is a final demand. Here, it's quite clear that $14,990 is probably not the right amount if $330,000 was in the realm of expenses that were paid by Medicare to care for this injury victim. So the law firm issued a statement, a response to the press release that had been released by the Department of Justice, and really they were arguing that they had done the right things and that Medicare gave them a number that they should have been able to rely upon. The problem with all of this is that you just cannot rely upon a conditional payment amount. It does not bind Medicare, only the final demand. So you have to give Medicare your settlement detail, and then they will issue a final demand. There are a few exceptions that you can get a final amount pre-mediation, and Medicare's website details the limited availability of that option, but you just have to realize that the final demand is the only thing that will bind Medicare. So you cannot rely upon amounts that you receive from Medicare or through the portal prior to giving Medicare your final settlement detail. This next settlement is important because it involved a law firm who referred a case to another law firm. The law firm that the case had been referred to did not resolve a Medicare conditional payment. The DOJ went after the law firm that referred the matter, and here ultimately got money from that law firm when the firm that the matter had been referred to did not resolve the conditional payment. And again, it says you cannot refer a case or enter into a joint rep agreement and wash your hands clean of the obligations to reimburse Medicare. And the settlement reminds attorneys of their obligations to reimburse Medicare for conditional payments after settlement, and that's no less true for plaintiff attorneys who refer a case to co-counsel or jointly represent plaintiffs. This last matter from last year, last settlement from last year, is here because of, one, the amount. It's a very small amount of money that the DOJ decided to pursue a law firm over, but also because of what the DOJ was asking, and this is the case with all these other ones I've discussed, making sure that there's a person responsible within the law firm to pay Medicare secondary payer debts, training that person to make sure that the debts are timely paid to Medicare. And then lastly, this bit about lawyers need to set a good example and follow the rules of the road for Medicare reimbursement. If they don't, we will move aggressively to recover the money for taxpayers. That says it all. If you are going to represent Medicare beneficiaries and ultimately resolve conditional payments at settlement, you need to understand what the steps are for a firm to resolve with Medicare. The process summary is, first, you've got to report the case to the BCRC. Then the BCRC will issue a rights and responsibilities letter. The BCRC will identify Medicare's interim recovery amount and issue a conditional payment letter. That's the point where you want to dispute unrelated charges. So you want to audit and verify the amount. Once the case resolves, you send a settlement notification, the settlement detail document to Medicare, then a final demand is issued. Once the final demand is issued, interest starts to accrue, and if it's not paid, then ultimately it will be referred to Treasury for collection after 90 days. So this is a handy dandy diagram of everything I just mentioned. When you look at this, you probably are thinking, why are we doing this? And that's a good question. In many instances, it probably makes sense to work with an efficiency and expert lien resolution partner like Synergy to take care of all of these steps to make sure that a step is not missed and you wind up with the DOJ breathing down your neck. So what happens once the final demand is issued? Well, you've got to pay that final demand within 60 days or the debt accrues interest, and the accrual of interest goes back to the original date the final demand was issued. If you request an appeal or a waiver of the Medicare conditional payment, it does not toll the interest. Interest is due and payable for each full 30-day period the debt remains unresolved, and by law, all payments are applied to interest first, principal second. Once you do finally pay the final demand, Medicare will send a letter stating that the lien or debt has been reduced to zero and the case is closed. So we've talked about process for conditional payments. Now, what do you need to know about the resolution of these conditional payments? There are three primary Medicare conditional payment resolution options. First is simply pay the amount if you've audited and make sure that unrelated care has been removed and verified that the charges are proper. Option two is appeal the amount that Medicare is claiming. There are 4 levels of internal appeals before you ever get to a federal district court, so it's quite lengthy. If you don't pay the conditional payment before initiating an appeal, interest continues to accrue. The third option is post-final demand issuance is requesting a compromise or waiver. If you're successful, Medicare will refund either partially or all of the amount that had been paid to Medicare. And the reason that option 3 becomes attractive is if you pay Medicare, it stops the interest meter from running. So if you choose option 1, there's 2 standard calculations that are used for reducing what's owed to Medicare. That's basically a procurement cost reduction. If what is owed to Medicare exceeds the amount of the recovery, then Medicare can take all of the settlement proceeds. So that usually is a situation where you've got no other option but to pursue a compromise or waiver of the amount due to Medicare. US v. Kerrigan is a cautionary tale and an example of the wrong way to go about trying to reduce a Medicare conditional payment obligation. So Mr. Kerrigan represented a Medicare beneficiary in a car accident case where a suit was filed. So Medicare was put on notice of the accident and lawsuit. Subsequently, a settlement was achieved and the details were sent to Medicare. Medicare sent an initial determination of what was due. Once that was received, Attorney Kerrigan filed a motion in Texas state court related to the amount due, asking a state court to reduce it. Ultimately, Medicare issues its final demand. Thereafter, Attorney Kerrigan sends Medicare a Texas state court order which reduced the amount of the Medicare conditional payment down by 90%. And then ultimately, U.S. Attorney filed suit against Attorney Kerrigan and his law firm in U.S. District Court for the Southern District of Texas for failing to pay the proper amount to Medicare. So what did Attorney Kerrigan do wrong? Well, what the government said is that ultimately a Texas state court lacked any jurisdiction to adjudicate Medicare's recovery rights. Sovereign immunity applied and the Texas court lacked subject matter jurisdiction over the case. And the government took the position that Challenges or disputes of conditional payments must go through an administrative appeal process that set out the regs to the Medicare Secondary Payer Act, and only after exhaustion of those levels of appeal can a claim be made in federal court, which has exclusive subject matter jurisdiction, and certainly not a Texas state court. And then ultimately they sued the attorney because an attorney who fails to reimburse Medicare is personally liable for that debt. So the key takeaway is make sure you don't attempt to reduce a Medicare conditional payment in state court because a state court has no jurisdiction to reduce a Medicare debt. You've got to go through the proper channels and use the proper methods to reduce a Medicare conditional payment. So what's the right way to compromise or get a Medicare conditional payment waived? Well, there are 3 statutory provisions under which Medicare can reduce or waive completely a conditional payment debt. The first is under a financial hardship argument. The second is the best interest of the program waiver. And the third is a compromise waiver. Through these different methods, you can make the arguments of financial hardship and also equity, or that it's just harsh to the Medicare beneficiary to enforce this debt. If you're successful in seeking a compromise or waiver and the final demand's already been paid to stop the interest meter from running, then Medicare will issue a refund of that amount to the Medicare beneficiary. I use this as an example because this is a real world application of a waiver request in a financial hardship settlement. This case was a 7-figure recovery in a negligent security case, tragic, devastating injuries to a grandmother who was at her granddaughter's birthday party when a gunman broke in and shot multiple people. She sustained some extremely life-threatening injuries, but survived and ultimately recovered a 7-figure settlement. But under a financial hardship waiver, Synergy's lien resolution group was able to get that $159,000 conditional payment debt completely waived. So it is possible to get great results even with a large settlement making a waiver request. So this shows you the kinds of results that we're able to obtain when we request a compromise or waiver. 78% success rate. Last year, we were able to secure over $1.4 million in refunds back to Medicare beneficiaries, and the average refund was over $24,000. Since we started offering this service, we've recovered in excess of $9.3 million on behalf of Medicare beneficiaries. A question frequently arises about a hospital refusing to bill Medicare. They can choose whether to bill Medicare or stand on their own lien rights, but Medicare interprets the regulations to mean that after 1 year, liens from a hospital must be released and they cannot collect from the beneficiary or from the settlement at that point. So, in that instance, if they are standing on their lien rights, they're only entitled to a reasonable amount in most jurisdictions, and Synergy frequently is retained to reduce hospital liens based on reasonableness arguments, and that is frequently very successful in getting a steep reduction in the amount due to a hospital. Now that we've talked about Medicare conditional payments, we need to turn our attention to Medicare Advantage plans, because frequently clients elect into a Medicare Advantage plan after an injury, or perhaps they were on it at the time of injury. And these liens, I call them a hidden lien, and if you miss one of these, it could be very costly for your law firm. Medicare Advantage plans are simply an alternative to Parts A and Part B traditional coverage that are offered by private companies that are approved by Medicare. The key thing about Medicare Advantage plans to recognize is that they have the same recovery rights as traditional Medicare, but they are usually more open to negotiate and reduce their liens based on equity and fairness arguments. But you have to know that that lien exists, and there's an issue when it comes to that, which I'll explain in a moment. So as I said, Part C plans have strong recovery rights. They're identical to Medicare's recovery rights. The critical issue here is that when you contact Medicare and ask for a Part C plan lien, they're going to tell you they don't have that information. So when Medicare gives you a conditional payment amount, they're only giving you Part A and Part B. If that client elected into Part C, you will not know. There's one giveaway to that, is that if a client has received a lot of care that Medicare paid for and the conditional payment is very low, then it's likely that they elected into a Part C plan and they have a lien, and you need to find out who that Part C plan is, because these Part C plans have an action just like Medicare for double the amount of the lien right. And there have been cases in several jurisdictions that have enforced double the lien amount against insurers. The Western Heritage case out of the 11th Circuit is a good example of that. And there are similar cases in the 9th and the 6th, but there are some cases that disagree with that as well. So you have to be understanding of what the law is in your jurisdiction, but be very careful about these issues because of the exposure. When it comes to Medicare Advantage liens, just like Medicare conditional payments, attorneys have personal liability. And a good example of this is a case where we were asked to assist a personal injury law firm that had been sued by an MAO plan for double the amount of the $191,000 lien claimed. The case was ultimately resolved confidentially, but this is an example of a law firm that missed an MAO Advantage Plan lien and then was subsequently sued for double the amount of the lien under the Medicare Secondary Payer Act. So you don't want to find yourself in one of those situations, is the key takeaway from this entire section. Before moving on from Medicare Advantage liens, I wanted to talk briefly about the PAID Act. The PAID Act amends Section 111 reporting. It's effective December of 2021, and it will allow RREs, which are the defendant insurers, to query to see if an injury victim has elected into an MAO plan. And it cures partially the current data gap where you do not know if someone has elected into an MAO by providing that information to the defendant insurer. The only problem is whether plaintiff attorneys will get the same information so that they can determine if an MAO plan has paid benefits on behalf of their client, which in turn means that there may be a lien resolution issue related to MAOs. But it is a step in the right direction. So we'll have to see how that plays out next year once that system has been enabled for defendant insurers to query the system for Medicare Advantage Part C plan eligibility. Regardless of the PAID Act, the key takeaway from this part of the presentation should be it's your responsibility to identify Medicare Advantage Part C plan liens. So you've got to be a super sleuth. You want to make sure that you have copies of all of your clients' insurance cards documenting Part A and Part B or Part C coverage, and you need a process within your firm to have staff trained to find these unidentified Medicare Advantage plan liens. And if you don't want to do it yourself, then you should outsource to a lien resolution partner like Synergy. Our results typically speak for themselves, and we're very successful in getting large reductions on Part C plan liens. But the key is you got to know that it exists and make sure it's resolved. Now that we've talked all about payments that were made prior to the date of settlement, it's time now to turn our attention to the futures and Medicare Setasides and give you an overview of what the current landscape looks like. But first, let's talk about why this issue is so important. So with mandatory insurer reporting that I talked about earlier in the presentation, Medicare can deny treatment based on the information that's reported when the defendant reports the injury-related diagnosis codes. So Medicare has the information to potentially deny care, and if a client did get a denial of injury-related care, there are 4 levels of internal appeals that you've got to exhaust before you ever could argue that the denial was inappropriate in federal court. So that's a very long time that a client could potentially go without treatment if they happen to be one of the unlucky that Medicare targets for a denial of future care. Currently, there is no statute, regulation, or case law that requires a Medicare set-aside. It's a creature of CMS policy, but CMS has initiated a attempt to codify, and this screenshot shows you something that's currently, and has been actually for a couple of years now, sitting at the Office of Management and Budget. And basically it's a notice of proposed rulemaking to create rules that regulate Medicare set-asides. And as you can see with where the arrow is pointed, stating the rule would clarify that an individual or Medicare beneficiary must satisfy Medicare's interest with respect to future medical items and services related to settlements. So this is where we currently stand. There's nothing definitive, but yet we know Medicare's position is that you need to do something to make sure that the burden is not shifted to Medicare post settlement of a personal injury case. So what are the key takeaways about Medicare set-asides? Well, as I just stated, there's no law, so in my opinion, it's analogous to a situation with a client who's on Medicaid and SSI. You've got to explain to them that there's this thing called a special needs trust. So with Medicare beneficiaries, you do the same thing. You explain there's a thing called a Medicare set-aside. This potentially protects your future Medicare eligibility. But remember, this issue only arises with clients who are current Medicare beneficiaries, so someone who's disabled, 65 or older, end-stage renal disease, ALS, or a disabled adult child. Arguably also those who have a reasonable expectation of Medicare entitlement within 30 months. That's someone that's already on Social Security disability and will have Medicare within 24 months. But also just remember that just because somebody does fall within those categories, that doesn't necessarily mean they need a Medicare set-aside. It means that you need to do an analysis, but they could elect into a Medicare Advantage plan. They could go private insurance route. They could self-pay. They could do a medical management trust for future medicals, or a structured settlement where the burden is not being shifted to Medicare. But if a client is Medicare eligible, they're going to treat in the future for injury-related care, and they're receiving dollars to fund future medical care. That's where you want to consider whether an MSA should be established or go an alternative method. And as I've said many times, Medicare's position is that an MSA is the preferred method to protect the Medicare Trust Fund, but that is just CMS's preferred method. There are many alternatives, and those are the things that have to be considered. So when you're representing a Medicare beneficiary, the question is, how do you make sure that you're MSP compliant in the way that you are closing out that case? Well, you want to make sure, first and foremost, you start early on in the process, compile all the public benefit data for disabled clients, make sure you know exactly what they're receiving in terms of benefits. If you have a Medicare beneficiary, then you want to make sure that you are in control of the Medicare secondary payer process from start to finish. And that means a little bit of collaboration with the other side, but a little bit of collaboration will go a long way towards making sure that there are not issues with the MSP at the 11th hour. But if there is going to be a Medicare set-aside analysis for futures, or there are conditional payment issues or advantage plan liens, you want to make sure that you have your own experts. You do not want to rely on the defendant's people to solve these issues, since you yourself have personal liability when it comes to this. And when a case settles, you really have to make sure that the defendant is reporting the proper information under the mandatory insurer reporting. You can do that either by indicating in the release what will be reported in terms of ICD codes, or a separate written agreement with the defendant. My suggestion is that you develop a process within your law firm to help you identify cases that involve a Medicare beneficiary, because you need something in place to make sure that if future medicals are funded by a settlement, that client gets educated about the risks of not doing a set-aside, that there could be a denial of care, and helping guide that client decide what to do, whether they do just a set-aside analysis or whether they actually set something aside. And the acronym I used early on in this presentation is also applicable. You want to make sure that you're consulting with the client, consulting with experts. You want to make sure the client is advised about the Medicare Secondary Payer Act, and then document your file about what ultimately is being done for MSP compliance. Now we'll turn our attention to ERISA lien resolution issues and reductions despite the McCutcheon U.S. Supreme Court case. When it comes to determining how to approach an ERISA lien resolution issue, first and foremost, you got to know whether it truly is an ERISA plan. So ERISA governs employer-employee plans. The exceptions are if the employer is the federal government, then FEBA applies. If the employer is state government, state law applies. If the employer is a church, state law will apply. Assuming the lien is from an ERISA plan, then the next question is, are they a self-funded plan or are they fully insured? If it's self-funded, then ERISA will preempt state law, and you're dealing with McCutcheon type arguments from the ERISA plan recovery contractor. If it's fully insured, then they're going to be subject to state law requirements, and it's quite a bit easier to negotiate and resolve those. So how do you determine if it's self-funded or not? Really, you've got to make sure that you've gotten a copy of the plan documents, so Form 5500. You can ask the plan administrator or recovery agent. One of the shortcuts is to look at what the name of the plan is. Sometimes that will give you a hint. If it is a named employer group or titled as an ASO, it's likely self-funded. If the plan is a named insurance carrier or titled HMO, PPO, or POS, then it's likely a fully insured plan. If you have an ERISA plan and it is self-funded, then you want to do what's called a 1024-B4 request to the plan administrator, because what that will provide you with is a copy of the SPD, master plan, annual reports, terminal reports, bargaining agreement, the trust agreement, administrative services agreement. But you have to make sure that you ask the correct party. This disclosure requirement is imposed upon the plan administrator, so you can't send a request to a TPA or recovery vendor like Rawlings, Conduent, Optum. They're never going to be the plan administrator. So this request has to go directly to the plan administrator for it to be an effective tool to, one, get you the documents you need, and what I'm going to talk about on the next slide, which are start triggering penalties. When a plan administrator gets a 1024-B4 request, if they fail to comply, there are two provisions in the law that provide for penalties, and on this slide you'll see a whole bunch of cases where those penalties were imposed. The beauty of triggering penalties is it gives you some leverage. Those penalties could exceed the lien amount in certain instances, but when you're not getting what you have asked for, there is this hammer of penalties. When it comes to your plan of attack against an asserted ERISA lien, it's really important to make sure that you've gotten what you've requested under the 1024-B4 request, because one, that gives you the leverage of penalties being assessed if they fail to comply. If they do comply, then you need to review the plan language, see if it reaches first party coverage, does it overcome made whole, does it overcome common fund, because the key to the McCutcheon holding is that if the plan documents do say they overcome all of that, then that's what governs. And so the strength of the arguments for reduction of an ERISA lien are going to turn on that plan language. So that's why it's so important to get everything that you request as part of this 1024-B4 request, and then review it and make sure that you completely understand what that plan says to attack it from the right angle. Some clients may be employees of the federal government or may have served in the military, which means that they will ultimately have coverage either through FEBA or through one of the military plans. When it comes to FEBA, these plans have the U.S. Supreme Court on their side. The Neville's case is the seminal case, and basically it holds that FEBA preempts state law, and so FEBA liens become a lot like ERISA plan liens in that they have very powerful recovery rights, but typically FEBA plans are a little easier to negotiate with and resolve than ERISA plans can be. And then military plans such as VA, CHAMP VA, TRICARE, they're all governed by the Federal Medicare Recovery Act. So that's the strength of their claims turns on that federal law. What you run into with the military liens are these protection agreements where the government is seeking to prevent an attorney from assessing fees or costs on the quote-unquote government portion of the recovery. We typically don't recommend signing these agreements. And then also when it comes to military liens, the question is whether the government can recover under the FMACRA from first party benefits, and that's the Andrew card case. So just things to be aware of when it comes to these lien types. So when you have a complicated case where you've got lien resolution issues or Medicare compliance issues, government benefit issues, or complex planning that needs to be done for an injury victim, one of the things that can be utilized is a qualified settlement fund because it creates some time and space, and I'll explain why in a moment. If you remember at the beginning of this presentation, I talked a little bit about a constructive receipt. And constructive receipt is a tax doctrine which you don't want to trigger if the client is in need of a structured settlement. But there's some other reasons why you just simply don't want to trigger it. But basically, when you take money into your trust account, you've triggered constructive receipt. And there's really only two ways to avoid triggering constructive receipt. Either the defendant holds on to the funds, or you can create a qualified settlement fund to hold on to the funds while the issues that I talked about, which are lien resolution, Medicare compliance, government benefit preservation, or structured settlements, are analyzed and figured out what to do. So all a qualified settlement fund is a holding tank. It's a trust created pursuant to Treasury regulations, and it allows you to settle a case like you're settling it for cash. It can be used in single event or group project cases or mass torts where there are multiple plaintiffs. The reason you do it is, as I said, it gives you time to plan. You can set up a structured settlement, set up an SNT, set up an MSA, do all of that while the funds have been immediately obtained from the defendant, and it avoids constructive receipt. The only drawback is it does require court approval, and there's some additional expenses to creating one of these funds. There are certain cases that are best suited for qualified settlement funds. So one situation is where you've got multiple claimants and you have allocation issues between the different claimants in terms of the amount of money being assigned to their claims. If you've got multiple layers of coverage and you want aggregate settlement funds, if there are complex lien resolution issues or public benefit planning issues, or a structured settlement is desired, whether it's the client or an attorney, or if you have all of that going on, that's a perfect case for setting up a QSF. So as I promised at the start of the presentation, I was going to cover a bonus topic, and that final topic is settlement planning options. This winds up being a topic that gets overlooked quite frequently, but as I started out the presentation, there are some obligations to advise clients about the law. One of the things under the law is the options that a client has under Section 104A2 of the Internal Revenue Code to take the settlement in the form of a lump sum or a structured settlement. And really what this boils down to is making sure the client is advised about these options, making sure they understand they could do a variety of these different options. They could allocate money to cash up front, some in a structured settlement, some in a trust. But the key is making sure the client gets educated. And if you are entering into a structured settlement, you've got to make sure as a personal injury attorney, you've got an expert advising you. Because of rated ages and annuity rate differences, you've got to have someone analyzing what's being done for that client to make sure it's in their best interest. You want to make sure to reduce default risk by split funding structured settlements amongst different life insurance company carriers. You want to analyze the life company ratings. You want to make sure there's sufficient liquidity at death with a commutation rider if estate taxes or liquidity is needed at death. And you want to make sure that you avoid triggering constructive receipt. I always end one of my presentations with a shot of our team, and this was from our last annual meeting. And We have an incredibly talented and dedicated team who believes in our mission of improving the lives of the catastrophically injured. They come to work every day and fight for what's best for the injury victims that we work with and allow trial lawyers to focus on what they do best by handling these difficult issues at settlement. And we are one of the fastest growing companies in America because we really believe in our mission and we're very, very good at what we do. So when you need an expert and efficiency partner to help you deal with difficult issues with healthcare lien resolution or Medicare compliance, government benefit preservation, settlement planning, or if it's a group project situation, or you need advice on deferring your attorney fees, those are all things that Synergy can help you with. So we are a comprehensive, holistic settlement solutions provider for personal injury law firms all across the country. And top law firms rely upon us as a partner to make sure that their cases are closed compliantly. If you have any questions at all from today's presentation, my email is on this slide, as is my direct line. I do a lot of consulting for personal injury lawyers all across the country and always happy to answer questions if you find yourself in any of the situations I talked about during today's presentation. Thank you for tuning in to Synergy's third Thursday webinar.